So let me just say briefly, I want to explain why do we need judicial reform? What's the problem that we're trying to solve? Okay, and what's actually in the judicial reform? The thing I love most, by the way, is when people come over to me and they say, that judicial reform that you're responsible for, it's horrible. It does terrible things. I say, okay, could you tell me which part of the reform is it that bothers you? And they go, hamina, 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 right? It's like Jackie Gleason and the Honeymooners, right? It's like they have no idea what's in the reform, right? Okay, so what I want to do now is so that everybody knows what's in the reform, okay? I am going to review what it's all about and why we need it. The problem is that all the checks and balances that exist in other countries do not exist in the state of Israel. The court can do whatever it wants. Okay, so what's the judicial reform doing? The judicial reform is trying to rein in the courts. There's one more thing that the court did besides for everything I said, which is eliminate all checks and balances. The court also decided that they don't want to wait for cases to reach them in order to tell the government what to do. What they did is they said, the Attorney General, he's the long arm of the court within the government, right? So now, in addition to the court having absolutely no checks and balances on it, in addition, it's got this insane thing where they've got this Attorney General who can push the government around on their behalf, right? Okay, so that's the situation we're living in. And now, what does the reform do? The reform has 5 parts to it. And I'll tell you exactly what the 5 parts are, and you'll understand why they're all necessary. The first part is, what is the job of the Attorney General? The reform says the job of the Attorney General is to advise the government on legal matters. The Attorney General is not the boss of the government. The Attorney General is the advisor. The government should hear the advice of their lawyer and then decide whether they want to take that advice or they don't want to take that advice, just like anybody else in the world who has a lawyer, right? You've got a lawyer, the lawyer comes and says, I'm telling you that I think, according to the law, you should be doing it this way, not that way, or whatever. You hear them out, and then you decide if you're going to take that advice or you're not going to take that advice. Okay? And moreover, when if the Attorney General is not going to defend you in court, and you're not satisfied with the defense you're going to get from the Attorney General or his proxy in court, you could just hire your own lawyer. You don't have to have the Attorney General as your lawyer. That's part 1 of the reform. Seems pretty obvious. Okay, let's move to part 2 of the reform. Part 2 of the reform is, how do we appoint justices in Israel? Okay, well, as we know, the current system, judges have an effective veto over new judges, right? That's just not normal. It doesn't make sense. It causes the court to be too homogeneous. It doesn't make the slightest bit of sense. And the idea is to simply change the composition of the panel, right? There are different ways to do it, and there are a million different discussions going on about how to do it, but the short version is you want the judges to have less influence over the appointment of new judges. That's it. The details, whether you want to give the opposition a little bit more representation or you want to give them less representation, coalition, opposition, people are haggling over numbers, 5-4, 6-3, it doesn't matter. The important point is you don't want the judges to have this veto, okay? That's part 2. I think it's pretty obvious. All right, let's go to the next 3 parts all have to do with the tools that the judges have in order to intervene in decisions or laws that are made by the other branches of government. So let's start with administrative actions, right? So what the court has decided, Barak in 1981, and been using it since then in all kinds of random and crazy ways, is the court can just say, we disagree with that decision, we find it unreasonable. So part 3 of the reform says, you could strike down administrative actions for a million different reasons that are all legitimate, but you can't just say, we don't agree with that, okay? That's not grounds. Saying it's unreasonable is not grounds, okay? So that's the 3rd part of the law, and that is also completely obvious. Parts 4 and 5 are both about striking down laws. Part 4 is another one that's completely obvious, which says you can strike down a law, but you cannot strike down a basic law. You can't. You cannot hear a case about basic laws. So part 4 says anything that's a basic law cannot be struck down no matter what. That's also totally totally obvious, okay? Finally, we get to part 5, which is, can the court use basic laws, i.e. what they call the Constitution of the State of Israel, in order to strike down ordinary statutes? And now, until now, the law never said that they could, but the fact is they've been doing it, right? So the idea is to regulate that and say you can do it, but these are the conditions. First of all, there were 15 judges on the Supreme Court in Israel. Now, in the United States, there were 9, okay? Now, the difference is, however, in the United States, all 9 judges sit on every case. In Israel, there are 15 judges, but sometimes you can have as few as 3 judges sitting on a case, right? And by the way, everybody knows the judge's opinions in advance, right? And when the Chief Justice of the Supreme Court decides who's going to be on the panel, right, pretty much you've heard the panel, you know the outcome, all right? When somebody said, when she decides that some panel is going to have Daphne Barak Erez and Uzi Fogelman on the panel, forget about it, man, okay? This is the hard left. You know exactly what they're going to decide, right? So the first thing is, if you want to strike down a law, you've got to have the full panel of 15. The reason you want the full panel of 15 is the minute there's any kind of leeway for the Chief Justice to decide who's on the panel, she's going to decide the outcome by picking the right judges. You got to have all 15. And if you're going to strike it down, you need a special majority, because this striking down a law is anti-majoritarian, right? That law was passed by the elected representatives of the people, right? So if you want to strike it down, you need a special majority. So now they're haggling whether it's going to be 10, 11, or 12 out of the 15. Doesn't matter. The point is, the principle is you need a special majority, okay? That's also a no-brainer, all right? Fine. But there's one more element, okay? And that is, well, if the judges do strike down a law, 10 out of 15, 12 out of 15, whatever it is, the Knesset wants a second bite. They want to say, well, we want to override, right? If we vote to override, then even if you struck it down, it's not struck down. It's back in, at least temporarily, okay? This is the most controversial part of the law. It exists. The idea of an override exists in Israel. It exists in Israel. Israel has a basic law. It's Chofesh HaIsuk. They translate it usually into English as freedom of occupation, but that's an unfortunate translation. I think that's an unfortunate translation. But in any event, it's freedom of business is what it really is. And what happened is, because of a particular case that threatened Rabin's government back in the 90s, Barak himself came up with this idea, well, if we strike something down, we'll let you override it so that Rabin can keep his government together, right? Okay, so it exists in Israel. It also exists in Canada, right? It exists in Canada because of problems between Quebec and the federal government in Canada. We don't need to get into the technicalities, but it is, in fact, an unusual thing, and it is the thing in this law that frightens people most, right? Because you can imagine the government, the Knesset passing some crazy law, and then the judges would say, no, that really is crazy. Sometimes the judges are right. It's unusual, but sometimes they are right? Judicial review is right, and they strike something down. And then the Knesset could come back with 61 and kind of override it, and it scares people. Okay, I get that. That makes sense. And it'll probably come out as part of the negotiation and all that. But in any event, at least 4.5 out of 5 parts of this reform are no-brainers. The arguments against it are not really legitimate arguments. They are just bringing Israel closer to the way things are done everywhere else in the Western democratic world. And we can only pray for the success of this reform. Thank you.